I'll read it. Excuse if I don't. Not a good reader. This is Glick versus Kniffy. I'm gonna pronounce it Kniffy. It might be Kniff, but I'll say Kniffy until I know otherwise. Anyways, let's see. This is just about all the people and organizations involved. But right here, Simon Glick was arrested for using his cell phone's digital camera, video camera, to film several police officers arresting a young man on the Boston Common. The charges against Glick, which included violation of Massachusetts wiretap statute and two other state law offenses, were subsequently judged baseless and were dismissed. Glick then brought this suit under 42 U.S.C. 1983, claiming that his arrest for filming the officers constituted a violation of his rights under the First and Fourth Amendments. In this interlocutory appeal, the defendant police officers challenged an order of the district court denying them qualified immunity on Glick's constitutional claims. We conclude, based on the facts alleged, that Glick was exercising clearly established First Amendment rights in filming the officers in a public space, and that his clearly established Fourth Amendment rights were violated by his arrest without probable cause. We therefore affirm. Now here's what they're affirming. We recite the pertinent facts based upon the allegations of the complaint. Asociación de Suscripción Conjunta del Seguro de Responsabilidad Obligatorio versus Flores Galarza, accepting all well-pleaded facts in the complaint as true. Sanchez versus Ferreira Castillo. As he was walking past the Boston Common on the evening of October 1st, 2007, Simon Glick caught sight of three police officers, the individual defendants here, arresting a young man. Glick heard another bystander say something to the effect of, "You are hurting him, stop." Concerned that the officers were employing excessive force to effect the arrest, Glick stopped roughly 10 feet away. You guys see that right there? Glick stopped roughly 10 feet away and began recording video footage of the arrest on his cell phone. After placing the suspects in handcuffs, one of the officers turned to Glick and said, "I think you have taken enough pictures." Glick replied, "I am recording this. I saw you punch him." An officer then approached Glick and asked if Glick's cell phone recorded audio. When Glick affirmed that he was recording audio, the officers placed him in handcuffs, arresting him for inter alia, unlawful audio recording in violation of Massachusetts wiretap statute. Glick was taken to the South Boston police station. In the course of booking, the police confiscated Glick's cell phone and a computer flash drive and held them as evidence. Glick was eventually charged with the violation of wiretap statute, Massachusetts general laws, and blah blah blah, disturbing the peace and aiding in the escape of a prisoner. You get that? He was recording them beat and arrest a prisoner, and because he was recording him, they want to charge him with aiding in the escape of the prisoner. How fucking stupid is that? Acknowledging lack of probable cause for the last of these charges, the Commonwealth voluntarily dismissed the count of aiding in the escape of a prisoner. On February 28th, in the response to Glick's motion to dismiss, the Boston Municipal Court disposed of the remaining two charges for disturbance of the peace and violation of the wiretap statute. And by the way, New Mexico is a one-party state. I don't need nobody's consent to record them. With regard to the former, the court noted that the fact that the officers were unhappy they were being recorded during an arrest does not make a lawful exercise of a First Amendment right a crime. Likewise, the court found no probable cause supporting the wiretap charge because the law requires a secret recording, and the officers admitted that Glick had used his cell phone openly and in plain view to obtain the video and audio recording. Glick filed an internal affairs complaint with the Boston Police Department following his arrest, but to no avail. You know, those formal complaints are basically useless. You know, you gotta sue if you want any kind of change. The department did not investigate his complaint or initiate disciplinary action against the officers, arresting officers. In February 2010, Glick filed a civil rights action against the officers and the city of Boston in the United States District Court for the District of Massachusetts. The complaint includes claims under 42 U.S.C. 1983 for violation of Glick's First and Fourth Amendment rights, as well as state law claims under the Massachusetts Civil Rights Acts, Massachusetts General Laws, Chapter 12, subsection 11I, for malicious prosecution. The defendant moved to dismiss Glick's complaint under Federal Rule of Civil Procedure 12b6, arguing that the allegations of the complaint failed to adequately support Glick's claims and that the officers were entitled to qualified immunity because it was not well settled that he had a constitutional right to record the officers. At a hearing on the motion, the district court focused on the qualified immunity defense, noting that it presented the closest issue. After hearing argument from the parties, the court orally denied the defendant's motion, concluding that in the First Circuit, the First Amendment right publicly to record the activities of police officers on public business is established. This timely appeal followed. Denial of a motion to dismiss on qualified immunity grounds, unlike denial of typical motion to dismiss, is immediately appealed on interlocutory review. Sorry, it's a hard word. Interlocutory review. Garnier versus Rodriguez, Hunter versus Bryant, stressing the importance of resolving immunity questions at the earliest possible stage in litigation. We limit our review to the issue of the qualified immunity, which is legal determination that we review. Long-standing principles of constitutional litigation entitle public officials to qualified immunity from personal liability arising out of the actions taken in the exercise of discretionary functions. Harlow versus Fitzgerald. The qualified immunity doctrine balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Pearson versus Callahan. We apply a two-pronged analysis in determining questions of qualified immunity. Maldonado versus Fontaines. These prongs, which may be resolved in any order, require that we decide whether the facts alleged or shown by the plaintiff make out a violation of a constitutional right, and if so, whether the right was clearly established at the time of the defendant's violation. The latter analysis of whether a right was clearly established further divides into two parts: the clarity of the law at the time of the alleged civil rights violation, and whether, given the facts of the particular case, a reasonable defendant would have understood that his conduct violated the plaintiff's constitutional rights. An affirmative finding on these inquiries does not require a case directly on point, but existing precedent must have placed the constitutional question beyond debate. At bottom, the salient question is whether the state of the law at the time of the alleged violation gave the defendant fair warning that his particular conduct was unconstitutional. On appeal, appellants argue that they are entitled to qualified immunity on each of Glick's constitutional claims, and according that the district erred in denying their motions to dismiss. The arguments track the two parts of the clearly established right analysis. With regard to the First Amendment claim, appellants dispute the clarity of the law establishing a First Amendment right to record police officers carrying out their public duties. On the Fourth Amendment claim, appellants contend that in light of Massachusetts case law interpreting the wiretap statute, a reasonable officer would have believed there was probable cause to arrest Glick, and thus would not have understood that the arrest would violate the Fourth Amendment. We examine each argument in turn. Now, you guys can come back through and read, and continue to read. I want to get back down to the to the conclusion. Alright, sorry guys, I had to close the window and the curtain. The wind was getting too bad and the sun was getting bright. But anyways, it says, in the line with these principles, we have previously recognized that videotaping of public officials is an exercise of First Amendment liberties. In Ayacubuchi versus Bolter, a local journalist brought a 1983 claim arising from the arrest in the course of filming officials in the hallway outside a public meeting with the Historic District Commission. The commissioners had objected to the plaintiff's filming. When the plaintiff refused to desist, a police officer on the scene arrested him for disorderly conduct. The charges were later dismissed. Although the plaintiff's subsequent 1983 suit against the arresting police officers was grounded largely in the Fourth Amendment and did not include a First Amendment claim, we explicitly noted in rejecting the officer's appeal from a denial of qualified immunity that because the plaintiff's journalistic activities were peaceful, not performed in derogation of any law, and done in the exercise of his First Amendment rights, the officer lacked the authority to stop them. Our recognition that the First Amendment protects the filming of government officials in public spaces accords with the decisions of numerous circuit and district courts. Not just one, but numerous circuits and district courts. C. Smith versus Cummings, a very popular one that auditors like to use. The First Amendment protects the right to gather information about what public officials do on public property, and specifically a right to record matters of public interest. Fordyce versus Seattle, another one auditors will use. Another good example. First Amendment right to film matters of public interest, finding it highly probable that filming of a public official on street outside his home by contributors to public access cable show was protected by the First Amendment, and noting that at base plaintiffs had a constitutionally protected right to record matters of public interest. That was Demarest versus Athol. Channel 10 versus Gunnarsson, holding that police interference with television newsmen filming a crime scene and seizure of video camera constituted unlawful prior restraint under First Amendment. Remember that cop snatched the phone out of my hand. Schnell versus City of Chai, reversing dismissal for failure to state a claim of suit claiming police interference with news reporters and photographers' constitutional right to gather and report news and to photograph news events under the First Amendment, overruled on other grounds by City of Kenosha versus Bruno, Canal versus Town of Hudson, denying qualified immunity for First Amendment claim to police chief who prevented freelance photographer from taking pictures from a car accident. It is of no significance that the present case, unlike Ayacubuchi and many of those cited above, involves a private individual and not a reporter gathering information about public officials. The First Amendment right to gather news is, as the court has often noted, not one of those ensures solely to the benefit of the news media. Rather, the public's right of access to information is extensive with that of the press. Hutchinson's 438 U.S. at 16, Stuart J. concurring, noting that the Constitution assures the public and the press equal access once government has opened its doors. The First Amendment does not guarantee the press a constitutional right of special access to information not available to the public generally. Indeed, there are several cases involving private individuals among the decisions from other courts recognizing the First Amendment right to film. Smith, Robertson versus Fetterman, holding that arrest of individual filming police activities from private property violated First Amendment. Cirelli versus Town of Johnston, holding that teacher had a right under the First Amendment to videotape potentially hazardous working conditions at school, which were a matter of public concern. Moreover, changes in technology and society have made the lines between private citizen and journalist exceedingly difficult to draw. The proliferation of electronic devices with video recording capabilities means that many of our images and current events come from bystanders with a ready cell phone or digital camera rather than a traditional film crew. And news stories are now just as likely to be broken by a blogger at her computer as a reporter at a major newspaper. Such developments make it clear why news gathering protections of the First Amendment cannot turn on professional credentials or status. To be sure, the right to film is not without limitations. It may be subject to reasonable time, place, and manner restrictions. See Smith. We have no occasion to explore those limitations here, however. On the facts alleged in the complaint, Glick's exercise of his First Amendment rights fell well within the bounds of the Constitution's protections. Glick filmed the defendant police officers in the Boston Common, the oldest city park in the United States and the apotheosis of a public forum. In traditional public spaces, the rights of the state to limit the exercise of First Amendment activity are sharply circumcised. Perry, I guess education is something versus Perry local educators. Moreover, as Ayakubuchi, the complaint indicates that Glick filmed the officers from a comfortable remove and neither spoke to nor molested them in any way, except indirectly responding to the officers when they addressed him, such as me. I didn't talk to nobody but my viewers. Officers approached me, and that's when any conversation to the officers began. Such peaceful recording of an arrest in a public space that does not interfere with the police officers' performance of their duties is not reasonably subject to limitation. I'll say that again. Such peaceful recording of an arrest in a public space that does not interfere with the police officers' performance of their duties is not reasonably subject to limitation. So there you go, dude. Even 10 feet, I can get closer than that, as long as it's reasonable and I'm not interfering with you. Just because you're bothered that I'm there with a camera does not mean I'm interfering with you. In our society, police officers are expected to endure significant burdens caused by citizens' exercise of their First Amendment rights. See City of Houston versus Hill. The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. Indeed, the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. The same restraint demanded of law enforcement officers in the face of provocative and challenging speech must be expected when they are merely the subject of videotaping that memorializes without impairing their work in public spaces. And it's going to go on about the right to film being clearly established and this and that. So anyways, there's the case law on that, guys. Glick versus Kniffy. Look that up. I urge you guys to look it up and read it in its entirety. And yeah, so I urge all auditors and police, cop watchers, and basically anybody who's gonna pick up their camera or their cell phone and record police in the course of their duty to have this right here in their back pocket ready to present to them if they try to give you any shit about officer safety or you interfering or interjecting or whatever the hell. So here, this is just one case law, guys. There's another one, and there's a lot more case laws that back that one up. This is just the one that I had readily available, and I would have cited to the guy, but I didn't get a chance to. And anyway, so here's the education part some of you guys are looking for. If y'all didn't want to listen to me the first time, these cops I'm talking to, well, here you guys go now.